네, 이제 본격적인
We'd like to begin
안내 말씀 한 번 더 드리겠습니다.
session 2, and
네,
before
오늘
that,
저희 토론
I repeat the
참여하시는 동안
announcement.
궁금하신 내용
If you have any
있으시면요.
questions while
메모를
listening to the
주셨다가
forum,
그
please
뒤쪽에 마련되어
make
있는
notes of
구글
them
데스크에
and
메모를
submit
전달해 주시기
them at the
바랍니다. 저희
registration desk
담당자가
at the
내용을
back of the
수락해서
room.
저희 마지막에
Our
있으시는
staff will
토론
collect
때
those
이
questions
질문과
and
이야기 갖고 여러분들과 이야기
provide them to
나눠주시면
the
가장
moderator for
유용하고요.
the panel discussion
포럼
at the
저희
end of the day.
유튜브에 지금
And
실시간 채널 두 개가
for the
열려
online
있습니다. 저희
participants,
회사의
if you have
타이틀을
any
검색하셔서
questions
들어가신 다음 댓글창에 질문
after
사항들, 궁금한 내용들을
searching the
입력해
title of
주시면
the
저희
event on
제작진에서 이
YouTube
내용
and
갖고
finding the
주말
stream,
함께 함께
please
이야기
upload any
나눠보는
questions on
시간이
the
되겠습니다.
chat feature and
자,
we
이제
will have them
본격적인
entertained
세션
in the
2 시작해 보도록
final panel
하겠습니다.
discussion. We'd like to begin
지금부터는
the
디지털과
second
메타버스 국제
session.
포럼 두 번째 세션
This is the
이어가고요.
second
네,
session of
메타버스나
Global Forum
지식產업
on
이슈,
IP and
등 다양한
Metaverse.
주제로
Session 2 is on
진행해볼
direction of
예정입니다.
response to intellectual
먼저
property
일단
issues in
디지털
Metaverse.
총괄이신 쉐이노
First of all, we will have Mr. Shane O'Reilly, Director and Associate General Counsel at Meta, be speaking about IP issues in the metaverse of the United States. We will refrain from applauding when I give you the presenters. Now, Mr. Shane O'Reilly, on stage, please.
All right. Thank you so much. It's an honor to be here and be able to spend some time with you today. Do want to congratulate the organizers of this conference because I can say this is one of the best conferences I've attended on IP issues in the metaverse. As the announcer mentioned, my name is Shane O'Reilly. I'm Director and Associate General Counsel at Meta, where I lead a team that is focused on technology transactions, all IP issues related to licensing, open source, academic collaboration, sponsored research, and then mergers and acquisitions, and also involvement in standards organizations. I mention that and provide that background because it's going to provide context for this presentation, and I'll be able to talk about some of the experiences that I'm having. Metaverse. I know we spent quite a bit of time talking about the metaverse, talking about what it is. From Meta's perspective, it is the successor to the mobile internet. It is an environment that is much more immersive, that allows you to move through digital spaces, and it's an environment that is much more social. It allows you to have more immersive and social connections with people that you want to spend time with. From my perspective, I think ultimately connects you closer to extended reality. It makes it a more common form and portion to our day-to-day. Extended reality, I think as many of us know, augmented reality, virtual reality, and then mixed reality. I'll briefly talk about augmented reality, virtual reality, just so we make sure we have a common knowledge. And then I'll spend some time talking about mixed reality, because mixed reality is frankly where we've invested as a company pretty heavily. Augmented reality, this is just kind of a straight Instagram filter. Augmented reality, you're augmenting or manipulating reality in some way, shape, or form. That's an image that lays on there. Everything else in the background appears the same, except you have this digital lay that's placed there. Same thing, Google Map, hold up your phone, you've got this digital arrow that's showing you the direction you need to go into. Virtual reality is completely virtual, and we've talked about some of this earlier today. Roblox, Minecraft, when you think about the metaverse, all of that falls within this particular falls within that particular context. From a US perspective, what you end up hearing about probably the most is going to be Horizon Worlds, which is Meta's product, Decentraland, and then also Sandbox. Those are going to be kind of some of the main virtual worlds you'll hear from a US perspective. Mixed reality, I talk about it as being the key to the metaverse. I think both virtual reality and augmented reality are vastly important to the metaverse. But mixed reality has been an area that we've invested in really heavily as a company. The way I define mixed reality, this is not a meta definition, this is mine. Fully immersive environment that ultimately ultimately connects the digital to the physical. It allows you to walk around, exist, and kind of live within the physical world that we do, but have much more digital aspects brought in. Probably the best example is the movie Ready Player One that some of you may have seen. Main character Wade Walker has this haptic bodysuit on. Somebody physically touches Wade's avatar within the virtual world. He feels it in the real world. Some of you may have also seen we have some interesting videos online that Meta's put up where we have a researcher that has a haptic glove on and her virtual avatar touches a ball within virtual reality, and she feels it on her hand in the physical world because of sensors on that device. So mixed reality. This is actually an image of our Horizon Worlds product and a meeting within VR within Microsoft Teams. So this is actually kind of shot from our MetaQuest Pro product device that recently came out. So this just shows a virtual meeting. It allows people to appear within that meeting, within their avatars. You could ultimately also see that connection to the physical world where you have those Microsoft Teams screens that show up that are people that are dialing in virtually. Something else I'll also flag is that you have this new employee orientation or this screen that's being broadcast, which could be something that's being broadcast from somebody's computer screen or device. Next thing, this is actually an image of our MetaQuest Pro device. The goal of the device is ultimately to potentially even replace a computer. With that device, you could see that this woman here has a keyboard. That device is paired with that keyboard via Bluetooth, and she's got three distinct screens that are up here that are being shown that she's allowed to interact with. So that's kind of present day mixed reality. I'll just kind of show you a quick 1-minute video that shows you where we're going as a company, where we're going as a company long term over the next couple years.
Be like. Imagine if you could be at the office without the commute. You would still have that sense of presence, shared physical space, those chance interactions that make your day all accessible from anywhere. Now imagine that you have your perfect work setup and you can actually do more than you could in your regular work setup. And on top of all that, you can keep wearing your favorite sweatpants.
Looking good. Let's get together real quick for a debrief.
I'm free now. Let's jump in. Hi.
Hey.
So what do we think?
I think it's ready.
Great.
I'll prep it for the presentation.
All right. Good luck.
Imagine a space where you can tune out distractions and focus on the task at hand. And when you're ready to share what you've been working on, you can present it as if you're right there with the team.
Wait, where's Mark?
I think he's in the middle of something.
Perfect. So that's where we're going as a company long term. Small form-fitting glasses that you're able to wear. Interaction with holograms. As you saw, the colleague wore a hologram and they were able to interact and work together. Also, ways to interact within kind of virtual environments as well, where you have virtual environments that are also connected to our physical environments. I just kind of provide that background because it provides some additional background and context for what I'll talk about from an IP perspective and some of the things that I'm seeing. One of the keys to building the metaverse is interoperability. And recently, there's been a Metaverse standards forum that's been formed, which is founded by 37 companies that are connected to ultimately ensure that interoperability happens, that you're able to basically take your avatar, your digital representation of yourself within one world, and be able to use that avatar within multiple worlds. As part of these standard forms and these agreements, there's going to be contribution agreements, and there's going to be IP and patent provisions associated with these forms. And in some of these situations, if you have certain patents or assets that you want to exclude from the other players or other members of these forms getting a license to, you need to specifically identify that you're willing to kind of exclude those, that you want to exclude these IP assets from that particular working group or from the other companies that you're partnering with and working with as part of this form to create those technical standards. So I highlight too, just the XR Association and Metaverse Standards Forum Association. There's going to be many more. Me and my team, we've been working on quite a few contribution agreements and dealing with some IP and patent issues associated with that in the background. One thing I do want to highlight is that one of the keys to building the metaverse as well is having a fully functioning economy. And I know one of the speakers described the goods and consumables across the metaverse. So ideally, if I have a avatar and I'm using that avatar within our Horizon Worlds product and I've got some value associated with that avatar, that value might be an NFT, it might be some type of cryptocurrency. I want to ultimately be in a position where I could take that avatar and use it maybe on a platform that Google builds or that Amazon builds. And there are ultimately underlying agreements that are going to be formed and created through those companies to ensure that any underlying data or IP associated with that avatar are able to move through those virtual environments. Hardware, and this is just key, I talked about it before, hardware is kind of the key to the metaverse. Ultimately, if we are not able to create devices that are small, form-fitting, comfortable for people to wear or that they want to wear, it's going to be hard to gain that widespread adoption that we would want. Apple and Google are rumored to have devices. I think within this environment, competition is something that is probably healthy and actually helpful to gain that type of widespread adoption. Transitioning kind of right to that first bullet point, with hardware, you're going to see an increase in the amount of patent litigation that happens. For purposes of the U.S., it means that you end up dealing with a lot more litigation in front of the International Trade Court, in which the primary remedy in front of that International Trade Court is going to be an injunction, right? So as a company that has traditionally been within the social media space to a company that's now focused on the metaverse and much more hardware focused, we've kind of shifted from being in a position where we spent more time in district court to where we might potentially end up spending more time within the ITC. Foreign litigation. Again, with hardware, you end up seeing more cases and locations in which, in jurisdiction in which your remedy is likely an injunction. So they expect that there's going to be more litigation in both the UK and in Germany. Patent filing increases. We personally invested in filing more utility patents associated to the metaverse, but something I also raise is whether it makes sense to strategically file more design patents associated with the metaverse as well. Ultimately, and I have a slide later in here, ultimately the goal is to get down to glasses that are kind of smaller and more form-fitting. And at a certain point, some of the devices tend to kind of look like one another. So does it make sense to have that additional layer of protection that's associated with design patents and not just utility patents? Partnerships, agreements, standard setting organizations. I touched on that before and how that falls within the context of interoperability. One agreement I do want to highlight is something that we've done is we partner with certain educational institutions that have created meta universities. They've created virtual universities within the metaverse, within our Horizon Worlds product. And with those universities, we obviously want to make sure that we are respecting their intellectual property rights. So there are agreements that we are forming with those universities to protect and cover their intellectual property while they are basically building a replica of the university within Horizon Worlds, and we're actually teaching their students within those digital environments. Intellectual property and data rights. This is actually one of my kind of favorite areas, and I think that's because you have the interesting issues around avatars and likeness, and what actually is your likeness within the metaverse. You know, if I ultimately, want to make my avatar look like somebody else, let's say maybe Michael Jordan. I want my avatar to look like Michael Jordan and not look like me. What protections do I have around that as a user or consumer of the metaverse, and what protections does Michael Jordan actually have in his own image and likeness? And I would say I think it's probably more of a platform-specific issue, because ultimately you have to rely on those platforms to enforce any intellectual property issues when they're giving notice of them. I could speak for us as being a social media company that has kind of a large platform already within Facebook and Instagram and WhatsApp. We had a kind of robust notice and takedown system set up for when any intellectual property issues were flagged for us. So now we're basically taking a similar notice and takedown system set up for our kind of family of apps for Instagram and Facebook, and we're taking that system and kind of creating that to function somewhat similar within our Horizon Worlds environment. But the reality is you still have to provide notification. You still have to do the research and the digging. But also, I think one of the other indications, one of the other interesting things that was mentioned earlier, I believe, by Professor Kim when he was talking about the Squid Games example, the 13-year-old Netflix finding out about that, is as an entity and a corporation, whether you actually want to enforce those violations that you might necessarily see, especially if it's maybe increasing the brand, or letting folks know about your product, and you don't have the time or the effort, or you didn't even think about kind of creating that game or maybe that virtual world within that environment. So next slide. Significant rise in trademark applications. I think, there's a kind of U.S., at least every week within the U.S., there's some publication that says, oh, X company ended up filing for a trademark within the metaverse. And as was touched on in an earlier presentation within the U.S., it's still just kind of classifying. When you ultimately file and submit your trademark application, it's classifying that you want to trademark within certain areas. So, for example, Class 9 is virtual goods. Class 35 is also a form of virtual goods as well. And then 41, that kind of breaks down more specifically the types of goods there are. But we've seen an increase in filings related to the metaverse. Brand protection and enforcement, and I touched on this some a second ago. But again, if you want to protect your brand, strategically trying to find ways and partner with those entities and platforms as well to protect your brand within their virtual worlds and their virtual environments. I think, frankly, one of the difficulties is that I could go within Horizon Worlds today and go and create my own virtual world, and I could go and use, let's say, Nike's brand within that virtual world. So it's being strategic and ensuring that you have the lines of communication open and that you're creating those strategic partnerships so that you could possibly do something like use AI tools to identify violations and partner in that. And that's something that we're doing. But it's also helpful when you have that partnership and you have that strategic plan together around how to actually police your brand within these virtual environments. I just highlight within the U.S. there's this Nike StockX case. NFTs, and I would agree with the speaker earlier, NFTs are separate from the metaverse. However, NFTs are also and can be considered a form of value within the metaverse as well. Within my workroom, within my work area, within Horizon Worlds, I have an NFT that is up. That is my digital artwork within that workroom. And within that workroom, that's where I conduct all of my, a lot of meetings with my team, all my meetings with my manager. So I'd still say, well, NFTs are separate. They could still be included in portions of the discussion, but in this Nike StockX case, if you ended up buying a pair of Nikes on StockX, which is basically a reseller of Nikes, they would give you this NFT, which is a replica of a Nike. And StockX did not have permission from Nike before selling these NFTs. So that case is ongoing. I think will be a really interesting one, and it's pending in the Southern District of New York. So I will look forward to tracking that one and seeing how it goes. So potential issues in the metaverse, and I just kind of throw this up here just kind of as a quick highlight. I think for many folks, patent trade secret nerds and design patent nerds like myself might remember the big Apple versus Samsung litigation that happened. And as you know, that was kind of long, protracted litigation. Something I am, interested in and really curious about in the future is what do things look like when you have multiple companies that are working on hardware and working on devices that ultimately have a similar and kind of strong goal, and that is to get glasses that basically look like these pair of Ray-Bans that are down there at the bottom. So from a particular patent perspective and trade secret perspective, really interested to see what this landscape is ultimately going to look like maybe 5 to 10 years from now. So this is just kind of the last slide. Just wanted to highlight the amount of research and development that we spend to focus on creating hardware and devices that are focused on AR, VR, mixed reality, and frankly combine all of those as well. So these are just kind of a sample, only a small sample of the devices and investment that we've made as a company. Two other things I just want to highlight, and this is just because me and my team, we handle our mergers and acquisitions function as well. I think the interesting thing from an M&A perspective, especially that's connected to IP, is that a lot of the strategic transactions that we've made as of recently have been focused on display and optic companies that have pretty robust patent portfolios in patents. But at the same time, they actually bring the technology and the talent that's going to allow us to create the small kind of form-fitting glasses that we want. The second area of acquisitions, where we focused on quite a bit more recently, is gaming companies. Companies that will ultimately build content, a lot of it actually being focused on the VR function, but VR content that consumers want to use, that will really attract people to the device and want them to spend more time on it. One additional thing to mention that I didn't flag earlier is, again, I lead our IP licensing function, so patent threats. I've seen a pretty significant increase in the number of threats, and it's more from a licensing perspective. It hasn't got to the point where they've asked for, a request or a lawsuit, but an increase in the number of patent licensing threats that we've received that had been focused on metaverse-related technology. And that's, when I say metaverse, it's, interestingly enough, it's some patents that were kind of written, many, many years ago where somebody thought of creating a user interface for a virtual world, and it was that broad, right? And they had a few images and didn't have kind of much information beyond that. But now we're actually seeing that those patents that, in the past, kind of, pre-focused on metaverse, people may not have, may have been more difficult to enforce. We're now actually seeing a lot more of those patents show up, in those threats starting to increase within that area. So I think that is my presentation for today. Thank you again for your time.
네, 발표 드려.
Thank you very much, Mr. Shane O'Reilly, for that insightful presentation. Next, we will be hearing about trademarks and designs in the metaverse, legal aspects and practices in Europe, from the Minister Counselor Jörg Webender-Dorfer from the delegation of the EU to the Republic of Korea.
Annyeonghaseyo. Good afternoon. It's my pleasure and honor to be here. I would thank you and would thank the Presidential Council on IP, the Director General Jong-Won Lee, the Ministry of Culture, Sport and Tourism, and the Korean IP Office for the invitation. And my presentation will be a bit limited, particularly compared to the presentation we had this morning by Professor Ji-Young Han, which was excellent and very complete and covered all different rights related to the IP area. And not only this, but also the area of unfair competition and litigation issues. I have to say that I'm a bit jealous that you are able to talk about all these things. Why is that? Because, and I want to start with this because I think not all of you are well informed or so deeply informed about the EU IP situation. In the EU, we have some community rights, which means these are rights which are valid throughout the European Union. This is the case as regards trademarks and designs, and this is dealt with by the EU IPO, the IP Office of the European Union. Then we have other community rights, for example, plant variety rights, which are dealt with by another agency, or we have geographical indications, which are dealt with by the European Commission. So what is about patents and copyrights? As regards patents, we have an international organization, the European Patent Office, but this office is so far administering only national patents, which have a common procedure to come into existence, but afterwards they are mere national rights. There will be in future also unitary patents, which are also community rights with a scope all over the European Union. And so this is separate. So far we have neither unitary rights for patents, nor we have here Office of the European Union, but international office on its own rights. As regards copyrights, we have only national rights. This means we have tried to harmonize from the EU side via several directives the national laws, but there are no copyrights throughout the EU. This is still mere territorial principle. So what I talk today about is about the practice of the EU IPO. That's the IP Office of the European Union dealing with European trademarks and European designs. You have to see as well that these community rights are in parallel to the national rights. There's still national trademarks and national designs in each of the member states. As to know. So with all these limitations and complications within the EU, the last we needed was the Metaverse. And we are here really behind maybe certainly behind the developments here in Korea, and my congratulations to the authorities here that they have already some guidelines in place in this regard. So the EU IPO is dealing as regards questions on the metaverse, as regards trademarks and registered and unregistered designs. There are many open questions so far, not many answers, and we wait for case law as regards trademarks particular, and as regards revision of the design regulation. Why do I differentiate here? Because as regards trademarks, there was just a review of the regulation some years ago, so the next review will take more time. Whereas there is a pending review of the design regulations, and it is hoped that this area will be dealt with by this review. So as regards trademarks, there will be, of course, developments, but this will be rather in the hands of the jurisdiction. So I had just before in the brief discussion over lunch, of course, there will be legal development. The question will be, is this done by the jurisdiction or by the legislation? So who comes first, or maybe the legislative or the executive power doesn't like really the jurisdiction, it will change the law afterwards. But there will be movement, and this is certain. As regards trademarks, I singled out 4 problems. The first is the classification of goods and services. So if you apply for a trademark registration, you have to classify goods and services, and there are absolute grounds for refusal. It means by the office it will be checked whether the trademark fulfills, meets all the conditions, particularly if it's distinctive and non-descriptive. And there are relative grounds for refusal, meaning there might be a prior right, particularly a trademark, which is in conflict with the application, and there is a question of trademark use. I come to the first issue, to the classification, and there are 2 issues basically. First, which classes are relevant, and secondly, how you have to describe the goods and services covered by the trademark. Typically, the class involved are classes 9 for goods, but also 35 and 41. At least it's the case at EU IPO. 35 is rather for promotional and marketing purposes, service in this regard, and 41 for entertainment services. Normally, descriptions are very broad and encompass many, many different virtual goods. What is the practice of the EU IPO in this regard? It doesn't accept virtual goods as such, meaning applicants have always to add some further specifications, for example, virtual goods, namely digital art. They are classified in class 9, and I have here some examples which are acceptable as indicated by the EU IPO. For example, for class 9, downloadable virtual goods, namely computer programs featuring footwear and clothing for use online and in online virtual worlds. This is also goods. And for services, class 35, providing an online virtual environment for trading virtual art and virtual art tokens. Or for class 41, for entertainment services, namely providing virtual environment in which users can interact for recreational, leisure and entertainment purposes. So, as I said, merely for virtual goods, it's not possible to register according to EU IPO practice. Coming to absolute grounds for refusal, so this is the question, particular whether or not trademark application is distinctive and non-descriptive, and the question is what criteria are decisive here. In general, it will be the consumer perspective. The consumer should see the representation as an indication of a commercial origin. That's very important. Of course, it will be the case that this signs will always reflect, or indications will always reflect the real world in a manner in which they are marketed. And this is just the essence of many representations in the metaverse. And the key question will be basically, will the consumer see this representation really as an indication of a commercial origin or not? And in this regard, it is clear that a mere banal representation of a real world good and services as such does not suffice. It's not sufficient. And if we see an example in this regard, we have here an application for a backpack with a for class 9 for downloadable virtual goods, namely computer programs featuring bags for use online and in online virtual worlds. So this is an application for bags, class 9, and the question is, okay, this is for the virtual world. Is here the consumer perspective the same or not the same? Should I have here different criteria to evaluate how the consumer will perceive this trademark? But in this case, it's rather clear, so it would be a rejection of the trademark application, because it's just a banal representation of a bag. There's nothing special on it. There's no indication of commercial origin from the perception of an average consumer. I come to relative grounds of refusal. As mentioned, relative grounds of refusal, these are the cases where at a later stage trademark application is opposed or later on attacked by a cancellation action by holders of an earlier right, particularly earlier trademark. And then we have the question, what happens in conflict situations between virtual goods and real goods? Yeah? Is there a similarity? Is there a conflict? Normally you have a likelihood of confusion, which is the main key question, if the goods are identical and or similar and the signs are identical and or similar. So, and this leads to confusion in the public as regards the commercial origin of this good. So is this the case between goods from the virtual and the real world? And the question is for us in the EU IPO whether we can adjust nonchalant, apply the same criteria we always apply, because we have quite strict criteria defined by our Supreme Court in the canon judgment. In this criteria are whether they have the same origin or similar origin, purpose, nature, complementarity, competition, method of use, distribution channels, and the relevant public. If there are a lot of overlaps for this criteria, then it tends to come to the conclusion there is similarity. But is this a case between the real and the physical world? Or can we apply this criteria by analogy, or are there different criteria to be applied? Or should be there only a protection in case of reputation, but not in case of likelihood of confusion? I understand that in Korea, according to the guidelines, there is now not automatic similarity between virtual goods, but with the last guidelines, you have defined subclasses and you have to define similarity between them, but between virtual and real goods in general, you would say, according to these guidelines, as I understand it, dissimilarity, unless the earlier right has a reputation and some confusion can be established. So this would be rather going to the last point, that you give only protection in case of reputation, but not for usual likelihood of confusion. So this is not decided so far at the EU IPO. So we await there probably someday some case law, but these are all open questions and certainly very valid, all of them. Personally, for me, the most interesting area, having dealt with this since not so many weeks now, but dealing with this area and having worked a lot in the area beforehand, the question of use is very interesting. And I would say thank you to Professor Han that you mentioned it also this morning. Very valid point, because the question of use for trademarks is relevant in 5 different areas. First, if you have absolute grounds for refusal, let's say the mark is not distinctive, you can overcome this, or is descriptive, by enhanced distinctiveness via use. If you use it so much that everybody recognizes the trademark as a commercial, as an indication of commercial origin, you can nevertheless register it. For example, in Europe we accepted several plain colors, such sort of pink colors for telecommunication services, because it's so known in Germany, or the color for the chocolate Milka is also protectable in Europe due to its acquired distinctiveness. So in this regard, use is important. Then you can have a protection for trademarks even without registration according to Article 6 bis of the Paris Convention, even though the mark is not registered. So by mere use, if the mark has become well known in the public, you have all the protection, even though you haven't registered it anywhere. Then you get in the comparison between an early right and the application as regards the question of likelihood of confusion. According to European law, an enhanced protection, so the likelihood of confusion is enhanced to for signs or goods which are further away in case that you have established reputation basically via use. So as regards to your protection, you have another advantage here. Then you get also, according to Article 16 trips, you get protection for reputed marks also against dissimilar goods and services. So if you have an identical or similar sign and somebody else uses it for dissimilar goods and services, nevertheless you get protection if you can establish that your trademark has a reputation. So for this, use is also relevant. And finally, fifthly, and most importantly, you have to use your mark, or you don't have to, but if you don't use it, you can later not base it on any infringement action because somebody will request that you prove your mark and you will not be successful, or somebody can always challenge your trademark, the trademark registration after a lapse of time. In Europe, it's 5 years. You have a grace period of 5 years where you can use the mark, but you have to use the mark unless you are under danger to be attacked, or you cannot use your mark as a weapon against new applicants. So what is genuine use? So this, I just list this for what use is really relevant in trademarks, and this is a lot. And then the question is, what does it mean in the metaverse? What constitutes relevant use? Is it then only use in the virtual world, or you have to use it in the real world, or do you have to use it in a combined way? I mean, Professor Hahn mentioned it this morning. And what is about the territoriality? The whole IP system is based on the territoriality principle, where you have to use your trademark, and how you can prove this. What do you have as sources to prove this? These are very, very important questions. And additionally, as regards use, you have the requirement that you have to use it in the course of trade. So if you use it just in a sort of social media platform, I'm not specialist on this, but I can imagine sometimes it has no real commercial use. It's just for entertainment and maybe even created by somebody without commercial purposes behind. I think this will be an area which is certainly to be discussed in a lot of detail, and I haven't seen so far much on this, I have to say, in my brief research, but I think it's really worth it to have a focus on it and invite all the professors who are here and deal with this to have a look at it. I think it's a very interesting topic to have a debate what has to be done there, because these questions will come up quite rapidly, I think. So with this, I end my trademarks part and I come to designs. Again, from the EU IPO perspective, so from the EU perspective for the community designs, not from the perspective for member states for their national designs. There are questions as regards the definition of designs. If the definitions of designs are met, then there are questions as regards the necessary representation requirements, and then as regards the product indications, and then as regards the protection granted for designs. First, I want to bring also some virtual elements. What are digital designs? Can be icons, animated characters, holograms, or displays, projections, video games, virtual interfaces, voice use interfaces, virtual spaces. So there are now limits what can be a design. but the question is, do they meet the defined definitions defined in our Article 3 of the Community Designs Regulation? Just to mention, it's also a bit confusing in the European Union that we have a European Union trademark, but a community design. This also is linked to the review of the regulation as regards trademarks, but is still pending revision of the regulation on designs. So we will in the future also have a European Union design, not a community design. So the definition says design means the appearance of the whole or part of a product resulting from the feature of, in particular, the lines, contours, colors, etc. And in B, it says a product means any industrial or handcraft item, including inter alia parts intended to be assembled into a complex product, packaging, getup, graphic symbols and typographic typefaces, but excluding computer programs. So is this enough to see virtual items covered? Or is there some revision of the law necessary by the pending designs regulation review? And some possible amendments might be that we add in the text any physical or virtual industrial handicraft item, or say later in the example part that we add here graphic works or graphical user interfaces. So this has to be seen whether or not the legislator in Brussels, basically by the European Commission, will add this to the text. This might even not be necessary because there is in the EU IPO guidelines, it is said that designs of screenplays and icons, graphic user interface and other kinds of visible elements of a computer program are eligible for registration. So it might seem, in this slide, it might not be necessary to amend the text, but this is, as I said, to be decided by the people who review the regulation, the design regulation of the European Union at the moment. We come to unregistered design definitions. You have to see that in the European Union, we have some specific protection for unregistered designs. This is quite unusual. You get this protection, however, only against the copying of such designs, unregistered designs. And here, the definition says they must be made available in the public, published, exhibited, used in trade or otherwise disclosed in such a way that in the normal course of business, these events could reasonably have become known to the circles specialized in the sector concerned. So the question for me is there rather the second part, that they have become known or should have become known by the cycles specialized in the sector concerned, the normal course of business. Also in this regard, I have to say, if this is just, let's say, a social platform where some youngsters interchange some chit-chat, I don't know whether this would be then enough that the specialized circles would get knowledge of this. But this is quite a European problem because we have this unregistered design protected in Europe. Then we have the questions about the design representation. The question is here whether our regulation is outdated as regards requirements we set for depicting the design. And we have in our regulation stipulated the means of representation we can use. And we say can also 3D computer designs can help as additional technical means. Up to 7 views of the designs can be presented, and then there are some disclaimed features like broken lines, boundaries, color shading and blurring, separations. But the question is, does all this suffice to really show sufficiently design protection for moving designs, for animated designs? So this is also discussed and not clear whether we need an amendment as regards the possible design representation means. Finally, come to product indications, and there are some EU IPO recommendations for product indications. And you see the lower two are maybe quite clearer, because if you want to have, if a design is only incorporated in a physical product, you have to indicate only the physical product. If you have if you want to have the design protected for both real and virtual environment, you should indicate the physical and virtual product. But the EU IPO recommends as well, if you want to use it only in the virtual environment, nevertheless, you should indicate nevertheless the physical and virtual product in the specifications. Then finally, the question about the protection of design. So should there be a protection of real design against the use of design in the virtual world? And we have here a specific article on the scope of protection, Article 19 of our Community Designs Regulation, which says a registered community design shall confer on its holder the exclusive right to use it and to prevent any third party not having his consent from using it. The aforementioned use shall cover in particular the making, offering, putting on the market, importing, exporting or using of a product in which design is incorporated or to which it is applied, or stocking such a product for those purposes. In a presentation of the EU IPO, the people who gave this presentation said there should be in general no problem that this is included, because the sentence says in particular, so also the virtual use should be covered. This has to be seen, this is, as I said, might be either resolved by the revision of the Community Designs Regulation or by the jurisprudence on this matter. I would like only to mention that in my view there should maybe be some thought about a certain harmony. So if we say here there should be no problem to give design protection across the border from the real to the virtual world, then the question for me would be, why do you give this to designs and not automatically to trademarks, and say, like it is said now here in the guidelines, to give this only if you have a reputed or a well-known trademark and otherwise not. So why should be there a difference? You see, we have here still very, very basic and structural questions without answers, but there should be a certain harmony. And I think it will be very thrilling to see the further developments, both by law and also by the jurisdiction in this regard. What I would only plead for is that I would hope that in the future there will be a certain harmony in tendencies and solutions at a global level. Thank you very much.
네, 고맙습니다.
Thank you very much, Mr. Jürg Verdorfer, Minister Councillor, the delegation of the EU to the Republic of Korea. Now going to go on to the third presentation of session number 2. I would like to now call upon the stage Attorney at Law, Mr. Masafumi Masuda, who's going to talk about the policy trend and current discussion on Metaverse in Japan.
Hello, 감사합니다. 안녕하세요. Okay. This is Masafumi Masuda from Japan. Today I'd like to talk about policy trend and current discussion on Metaverse Japan. Just missing the title. Okay. I'm very humbled to be here. So before starting my presentation, let me introduce myself a little bit. This is my bio. I'm a Japanese attorney and mainly working for IT and digital matters, and especially Web3 related legal issues. You can see my major bio and current major roles on Web3 here. And for Korean speakers, 2 of my books have been translated into Korean. You may find more insightful information regarding Metaverse and Web3 in Japan. So let's start talking about Metaverse business environment in Japan. Quite a few B2B services have been developed, including service platform, development platform and tool, hardware, content and service provider, Metaverse builder, payment, consulting, and business development. Japanese industry is mainly focused on establishing use cases and developing Metaverse as marketing tools. In some aspects, Metaverse has a gradation. One, XR. Roughly 3 types of XR is in the Metaverse area, like alternative reality, mixed reality, and virtual reality. Discussion in Japan is mainly focused on VR. And number 2, Web3 or non-Web3. Although Web3 and blockchain is not a prerequisite of Metaverse, in the policy-making activities, the discussion in Japan is mainly focused on the aspect of Web3 and blockchain. So in my perspective, many major services make reproduction of the real world. The first one is Shibuya 5G Entertainment Project, Virtual Shibuya. And this is aiming to reproduce a real city. And the second one is Meta Platforms, Horizon Workrooms. This is aiming to reproduce a real situation to have a business conference. So I think that this is mainly because it should be somewhat similar to the real world so that we can use the virtual environment naturally. So next is growing homogeny with the real world may produce some legal issues. The first one is reproduction of things in the real world. It would cause copyright and trademark infringement, and also may cause property right issues for cultural properties and buildings like shrine or temple. And the second comes from the usage of person's face and appearance, and it would cause infringement of portrait rights and publicity rights, and also cause infringement of right to honor. And the last one is interpersonal contact. It's a very interesting topic. We may feel physical contact with others, even in a virtual world. And it may cause new type of perpetration problem. So let's move on to the policy-making aspect of Metaverse and Web3. This is an NFT white paper issued by the LDP, Liberal Democratic Party, the ruling party of the Japanese government. So the paper is a part of Digital Japan 2022, which is the proposal of the LDP, and mainly focus. An NFT white paper is mainly focused on the policy proposals on Web3 related issues. Such policy proposals by LDP is generally prepared by related divisions of the government. But since Web3 has a very large range and the related divisions diverge enough, actually there's no division who can deal with such a very large-scale topic. So the LBT decided not to ask the government itself, but ask some legal professionals, including me, to prepare the draft of the white paper. And the white paper, sorry, it's very small characters, but there are 24 proposals in the NFT white paper. And among all of them, there are 2 topics regarding Metaverse. This is the first one. The proposal starts the current situation. The current situation is that a vision of a future in which NFTs issued on a public chain serve as a means of achieving interoperability between services, allowing digital assets to be brought into and used in multiple metaverse services. But the challenges lie in how to standardize the mechanism for managing blockchain structure, NFT format, and digital data that is not recorded on the blockchain. So the proposal is, in order for Japanese businesses to secure a favorable business and competitive environment on the global market, the key point is how to engage in and lead the international discussion about establishing the de facto standards for each of the above mechanisms. And blockchain-related businesses and XR-related business should be established a forum for cross-industrial information gathering and discussion venue. This comes from that there are so many business industrial organizations in Japan regarding Metaverse. So like blockchain-related business organizations and via technology-related business organizations, and they cannot discuss each other. So this proposal means make them discuss together in order to establish or joining the international discussions on the standardization of Metaverse. Okay. So Metaverse and NFT are often discussed together, as you know, and it can be realized by utilizing blockchain and, the open metaverse concept, which is a consumer can use digital assets that can be used in one service and in another services. And it can be realized by utilizing a blockchain and distributed storage services, but it requires the standardization of specifications and rules. And last year, Mr. Mark Zuckerberg gave a presentation to change their company name from Facebook to Meta platforms. And he has been focused on not only just developing metaverse technologies and services, but also standards. So in his message, he said there needs to be interoperability. And after that, among other 36 companies, he established Metaverse Standards Forum. And it was formed by only 37 founders in June. But after 2 months, there are over 1,500 members. So I feel that the Japanese industries and the government cannot independently compete with such a global movement. So I'm now recommending that the Japanese policymaker and the government join and follow the discussion in the forum. So the second proposal in the NFT white paper regarding Metaverse is IP-related proposal. So the current situation is there are cases in which NFTs of digital data that imitate mass-produced products with a somewhat distinctive appearance and sold under the assumption that they will be used in the metaverse. But these mass-produced designs are often not protected by copyright. So the proposal is there should be a discussion about measures that can be taken against counterfeiting and the limitations of these measures based on current laws. And then, in the future, the relevant agencies should examine the possibility of amending the law, such as expanding the scope of protection under design rights. Actually, this proposal comes from some IP infringement lawsuits, including this one, Metaverse, which had been already discussed today. So let's see some IP laws regarding industrial design protection. The first one is protection by trademark rights. The Trademark Act offers the protection for three-dimensional shape trademarks. But there are some issues, including it is not easy for three-dimensional shape trademark to be registered as a trademark under the Act. And also, protected only where the mark is used as the indication of some products or services. So there's a very limited protection is offered to such a trademark or service mark. The next one is copyright. Copyright protection is also discussed. It was a big topic whether industrial product for non-ethic purposes can be protected under copyright or not. And the discussion by the decision by the Intellectual Property High Court in 2015, they said, even if an applied art does not constitute a work of artistic craftsmanship, if it meets the copyrightable requirements in paragraph 1, item 1 of the same article, which is the Copyright Act, it is protected under the same law as an artistic work. So even if the design product, it also can be protected under the copyright. So, but please note that as it may be the same as in other jurisdictions, copyright protection covers only somewhat creative works, and it still limits the range of protection. Okay, so the third one is the protection by design rights under the Design Act. So design rights mainly focus on design or mass-produced products. So there are some issues, including the protection of a graphical image is very limited. I know some jurisdictions have a protection on the design avatar on Metaverse. It can be registered in some jurisdictions, but in Japan, we don't accept such a avatar design as a design rights. And the second issue is it is required to harmonize with copyright protection and other protections on IP-related laws. Okay, and the last one is a bit tricky. The protection by Unfair Competition Prevention Act. So it prohibits some unfair competition activities, and it can work as an IP protection as well as other IP rights. And among dozens of unfair competition activities defined under the Act, item 3 which is described in the slide, prohibits the act of transferring, leasing, displaying for the purpose of transfer or lease, exporting or importing goods that imitate the form of another person's goods, excluding what which is indispensable to its function. So some imitation can be protected under the item, but there are some issues, including that the meaning of goods in the article and imitate of the article is unclear right now. And under this fair competition type, not an imitation but merely similar product is not protected. So the protection under the Act as an unfair competition is also very limited. Okay, lastly, I'd like to introduce some ongoing policy-making activities in Japan. Although this shows some policy-making activities in Japan, which I was involved in. So this is not a whole list for such a meeting or study meeting in Japan. I am deeply involved in the policy-making activities in some aspects, and you can see on the list not only each ministerial division, but also a political party and cabinet office itself is keen to discuss metaverse issues as well. So the Japanese government will review all issues and build the next strategy by next March. And each government division will start implement the strategy from 2023, the next year. So it's relatively shorter than the expected, but I'd like to finish my presentation. Thank you for listening. 감사합니다.
네, 발표가.
Thank you very much for your presentation. That was a presentation from Attorney at Law Masafumi Masuda. Let's continue on to the next presentation. I'd like to now invite onto the stage Mr. He Chang Kim, Director General of the Korea Copyright Commission, who's going to talk about the response to IP issues related to copyright in the metaverse.
안녕하세요. 한국 저작권위
Hello, everyone. My name is He Chang Kim. I'm the Director General of the Policy Research at the Korea Copyright Commission. So today I'm going to be talking about Metaverse and the IP issues, but I'm going to specifically talk about copyright-related issues. So it's really a big honor for me to be here to talk about the Metaverse and IP with so many prominent experts from a variety of fields related to IP. So the KCC is located in Jinju, and I got on the 5:40 bus, and it took me 4 hours to come to Seoul. So I think that if Metaverse is realized, then perhaps we'll be able to have this kind of conference in the Metaverse, rather than me having to ride the bus all the way from Jinju to Seoul. So anyway, first of all, I'd like to talk about how we have been following up on the different issues related to the metaverse. So the KCC and the MCST
에 대해서
have been following the new technologies that have been developing, and we have been continuously discussing how we're going to respond to these developments. So, for example, in 2018, we formed the copyright feature strategy, and we also formed then in 2021 the New Technology Environment Council as consultative group, where we talked about a different variety of different technologies like AI and 3D printing and blockchain, etc. And then since 2022, we have also formed a consultative group regarding the metaverse, the NFT, and the copyright. So we have started a full-fledged discussion and debate on the metaverse and NFT and copyright. So we'll be continuing this year our research on these topics, and we have also picked a few topics for discussion between the KCC and the academia and the industries. So we'll be talking about what some of those issues are, what copyright issues are being raised, and what they mean for our legal system. So I would just like to first of all say that my presentation comes out of the consultative discussions that we had in the group. So when we talk about metaverse, well, I don't think I have to go through the definition. People have already done that before me. But many people also talk about the infinite possibilities of the metaverse. And so the real world is going to evolve in the metaverse, and that is constituted of different contents. For us, that means copyrighted works. A lot of copyrighted works will be created and consumed and used within the metaverse, and obviously that will lead to a whole lot of copyright-related issues. So then there is an interaction between the platforms, and with that kind of interaction, I think the metaverse is going to expand. One thing that I felt was very important is that, of course, the metaverse strives to have this kind of expanded world. But if you look at the existing metaverse, they are just individual platforms. And so the contractual relationship within one platform is more important rather than the interoperability between the different platforms. But going forward, I think this kind of interoperability between the different individual platforms will become more and more important, and that will also lead to legal issues of its own. So here are some of the copyright-related issues on metaverse. I can't say we'll be talking about everything, but here are some of the main issues. So there are those issues related to the ownership and the attribution and liability of the platforms, etc. So the first kind of copyright-related issues pertains to the user-generated contents, or the UGC, and the attribution of the ownership in the metaverse. And so in a metaverse, the UGC is categorized into complete UGCs, but also partial UGCs. And so because these UGCs are created and consumed a lot in the metaverse, there are a lot of rights. But actually, these UGC-related copyright issues are not completely new, because we've had this kind of issues already in the real world, for example, related to StarCraft, etc. So you can just say that they have been translated into the metaverse. But one thing there is different is that the platform actually provides some of the elements that are needed in the creative work. So sometimes some of the UGCs in the metaverse can be seen as a derivative work and not just an original work. And so they lead to more derivative works. And so then there is a relationship between the different users and the creators. But many of the metaverse platforms provide terms of use, and they also encourage the users to create their own work. But anyway, generally, the copyright of a UGC belongs to the users, but the metaverse platform also provides for comprehensive licensing for the use of the content. But majority of the platforms actually only allow the UGC outside the platform for non-commercial purposes. So these examples are about Zepeto and some other cases, and the Hermes and Birkin that we've already heard about. So then how are we going to resolve these issues? What kind of perspective and angle should we take on? So first of all, the terms of the use usually is a policy on the platform. But like I said, there is a limitation to the scope of the use. And so one issue that arises from here is the fairness of the terms of the use of the platform. So the services provided by the platforms according to the terms of the use may also lead to the need for more research to provide better clarification of the terms of the use, to make the terms of use more clear. There are also a lot of limitation-related issues. So, for example, we have a provision in the Korea about the private copying. But then in the platform, you'd also not just have reproduction, but also transmission. But if inside the metaverse there is indeed a private space, and then can we apply the private use provision on that private space within the metaverse? And then if you have like an online class that takes place in metaverse, what exceptions and limitations to copyright would apply to the metaverse education space? So can we apply the provisions as they are, or do we need to revise them? And so one such example would be the freedom of panorama. So you have the existing buildings and architectural works, and they are reproduced in the metaverse. Do we have to have permission, or don't we need consent from the original creators when we have these buildings in the background in the metaverse? We have the freedom of panorama in the Korean Copyright Act. Of course, we did not take into account metaverse when we were actually inserting this kind of provision in the law, but it's really about photographs, and if you have these buildings and architectural works in the background, then they'll not be these kind of reproductions will not be, these reproductions will be considered as limitations or exceptions to copyright. But then when we go to the metaverse, it's not just about the buildings being in the background, it's also about the buildings being built and then being used. And so we might have to have an additional interpretation. In Article 35.5, we also have a fair use provision. So we sort of we referenced benchmark to the American law, but anyway, we have the fair use of work, so we need to think about whether this kind of fair use provision can also be applied to the metaverse and to what extent. So say that you have a photo or a video, but it's not just a reproduction. So if you're going to make something in a metaverse, you have to codify it. So this the act of codifying. Does it is the act of codifying a reproduction or an act of creating a derivative work? That is also another very important copyright-related issue. And also, I think we also need to make an active application of the fair use provision to be able to reflect the special circumstances pertaining to metaverse. So say there is a building and somebody is using the building to enhance the immersiveness of the metaverse. And so then the purpose of using that architectural building is different from the original work. So then if the use is different, then what kind of legal provision will be interpreted? But and another time the metaverse is directly using the architectural building, then that will be another story. The next thing I'd like to talk about is copyright-related issues pertaining to performances in the metaverse. So just like physical performances, you can also have a lot of performances in the metaverse. According to the Korean law, there are some provisions that can be applied, but the question is which provision can be applied to these performances in the metaverse. And in the process of the performance, many different works can be used. So how are we going to process the copyright, and what kind of royalties are we going to apply to performances in the metaverse? So these are some of the important questions that arises. Sorry, I'm just trying to look for the correct slide. So in the Korean law, we have what we call the public transmission. And then we also have the digital sound transmission and interactive transmission. And so the broadcasting is about simultaneousness of the sending and the receiving. And the real-time streaming, like the radio, that is defined as the digital sound transmission. So anyway, then if we have a performance on the internet, can we consider it to be simultaneous or not? Depending on the simultaneousness, we will be able to determine which legal provision could apply to the performances in the metaverse. And then that also has an effect in what kind of royalty and the level of royalty would be paid to the rights holders. So yes, in the end, ultimately, it's all about what level of royalty will be paid. So you have these online concerts. So if you have an offline concert, and if you then look at the online concert, and if you compare the two, what kind of profit structure do they have? So are they different? So if you look at the online K-pop concerts, it's actually the same as the offline concerts, the physical concerts, and it seems that the profit structure are the same, at least for now. But then if you look at the royalty, even if it was seen as a broadcast, then, and if you look at the profit structure, the royalties that are applied currently to broadcasting should also apply to the performances in the metaverse. So for now, I think that the broadcasting royalty could apply. The next thing I'd like to talk about is that there are some rights that were not so much the focus in the offline world, but has become more important in the online world. And one of those examples would be choreography. So there's a program called the Street Woman Fighter, and there are many dances. They showcase many of the new choreographies. So these many of the choreographers have now formed their own organization because they felt that in the past choreography were not properly recognized as copyrighted works. So when Psy's Gangnam Style was really popular, there's that kind of horse riding dance that was really popular, and many people criticized that not enough royalty was given to the choreographer who came up with that horse riding dance move that became really popular. So anyway, now there is a discussion about the scope of protection when it comes to choreography, because you have some basic steps and then you have the additional steps. There was one case where a certain K-pop choreography was seen to be copyrightable. So dancers and choreographers are also having a discussion about the scope of their rights, and they also have to have a more active discussion. So one dance step is not copyrightable, because if each step is copyrightable and is given exclusive right, then those individual steps will not be used by others. So in Korea, and I think in other countries as well, each individual step would not be copyrightable. So in a particular case, the whole dance was seen to be copyrightable, but then that leads to the question of the scope. With the motion capture technology development, a certain dance move can be differentiated with from other moves, and so then we will, I think, be able to better specify the scope of protection for choreography. And then I think we will be able to apply that to the metaverse. If that is indeed the case, well, of course, the each choreographic step might not be copyrightable in and of itself, but we may also be able to think about the attribution, because at least then at least the choreography could be protected by contract. So it's sort of like the TV formats. As you know, you have a big judicial precedence in Korea. So some courts said that it's not copyrightable because TV formats are ideas and not expressions. But nevertheless, the TV formats have great economic value, and there is a huge market for TV formats. And we can apply that to choreography. If it's a certain dance move and we can attribute it to a certain choreographer, and if there is a market whereby these kind of choreography steps could be traded, then I think a similar kind of legal interpretation could apply also to choreography. Now, onto the issue of the liability of the metaverse platform operators or service providers. So, as I had mentioned before, these platforms are constituted of a variety of different contents, and they are downloaded and uploaded by the users in the platform. And so the metaverse platforms is a mediator among the different users. Of course, if the metaverse platform creates its own content, then that'll be a different story. But if it acts like an OSP, a typical OSP transmitting the different contents, then it is indeed be applied with the relevant OSP-related provisions in the Korean law and other jurisdictions as well. So there are certain requirements for an OSP to benefit from exemption from liability. So they should not initiate the transmission of the works. They should not be able to select a work or its recipient, etc. So there are OSPs that are considered as hosting services. And so, once again, I believe that these metaverse platform operators could be seen as an OSP. So if the user, even if he or she transactions illegal content, then the OSP can benefit from the safe harbor provision. And also the metaverse platform operators could also benefit from the safe harbor provision. So I think this kind of exemption from liability is quite similar in many different jurisdictions. So, and also it's based on Section 512 in the American law. And I think there is a provider liability exemption provision also in the Japanese law as well. So if you look at the highlighted part, it says that a notice and takedown has to be provided, upon which the platform provider, once getting that kind of notice, has to have measures in place to take that posting down. So anyway, once again, the metaverse platform operators can be seen as an OSP, as a hosting service, and accordingly, regarding a lot of the illegal content, the metaverse platform providers can be exempt from liability, but they also have to have some protection measures in place and relief measures in place. So the platforms, after notice and takedown would then find out who the infringer it was, and then would take him or her to court. And so there were some litigations involving Roblox regarding this kind of liability issue. So I think these liability and copyright infringement related issues that had rose in the past in regard to YouTube and some other platforms would now appear also in the metaverse world. So then from the rights holder's perspective, he or she has to be able to track down where the violations are taking place. And if I, as a rights holder, have become aware of the infringement, then I have to send a notice to the platforms. But how can we specify that infringement? Right now, it's possible to do so by URL, but in the metaverse, it's really difficult to pinpoint and specify exactly what part of the work is an infringement. So in conclusion, regarding the methodology, the Metaverse platform service provider have to find a solution and have to be able to answer this kind of question regarding the possible infringement of copyright, because it also does have to play an active role in protecting copyright. Recently, the notice and takedown has evolved more. Now we're going to a stay down situation. Then the liability of the OSPs and the metaverse platforms can actually act as a monitoring role to ensure that the copyright infringement is prevented. And so these are some of the ways forward regarding copyright for the metaverse platform service providers and also the OSPs. So namely, I've been talking about a variety of issues related to the IP and metaverse. So in conclusion, I would like to say that the Korean copyright has to be reviewed. So do we need any immediate revisions to the copyright law to be able to accommodate these metaverse related issues? Actually, the copyright law, we've already had a lot of copyright issues arising from the digital world, namely from games and also from the Second Life and StarCraft, etc. And so the Korean copyright law and the legal interpretation are actually quite used to the application to the digital world. So I don't think we need an immediate revision. We also have a lot of general provisions like the fair use provision. So I think it's really about coming up with appropriate guidelines for the legal interpretation of the existing law rather than revising the law. We also need a concrete approach and practical approach are needed in order to facilitate the creation, protection, and the use of works in the metaverse. So I think the metaverse platform providers' terms of use have to be reviewed and to see if they are really appropriate and ensuring fair use. And we also have to be able to maintain a balance and maintain a balance between the different interests of the different stakeholders. So I would just like to conclude my presentation with those words. Thank you very much for your attention. Thank you very much, Mr. Hye-chan Kim, for your insightful presentation. It's been talking about the response to intellectual property issues and also some alternatives related to copyright in the metaverse. So let me now go on to the next presentation. It's actually the last presentation in session 2. I'd like to now call upon Professor Chang-Hwa Kim from Hanbak National University to talk about the response to IP issues related to industrial property rights in the metaverse, focusing on design and copyright. Let's welcome him to the stage.
Good afternoon. My name is Chang-Hwa Kim. I'm a professor at Hanbak National University. I would like to thank the organizers for inviting me to speak here. Today, I would like to speak about Response to intellectual property issues regarding industrial property rights in Metaverse. So before I go into my presentation, I would like to share with you how I came to this presentation. Well, the KIPO, KIPO, and I were involved in projects together. So last year we were working on a trademark-related research project, and this year we were working on a metaverse design project. So I was involved in the design-related project, and my colleague professors were working on the trademark project last year. So I would like to focus more about the design project and about the trademark project. I will be sharing information that I've gathered from the reports that were generated by my colleague professors. Now, first of all, in the digital economy, the metaverse that is quite similar to reality has emerged. And in this new digital reality, digital products and digital articles have emerged. And Design and Trademark Act, how those digital products and articles are defined according to that law has become an issue. So to solve these questions, we would like to look at, we have actually already pursued a lot of projects to look at how these items are interpreted according to current law. So first of all, on the limitations of design protection and the broad definition of the Design Protection Act selectively focuses on product design as the main object of protection and requires an article as an element for establishing a design. So the design needs to be specified on an article. And so we were focusing only on the product design, and it was clearly defined that it would have an article as an element. And for this to establish a design, it requires an article as an element. And by article, it means that the design needs to be specified on an article. But in the age of the metaverse, designs without articles started to emerge. And for those designs that are not assigned upon articles, how those designs are going to be protected has become an issue. And in particular, last year and this year, with the rapid emergence of Metaverse as a major figure in the public's lives, the article requirement need to be resolved. So new laws had been enacted and examination criteria has been set down. And in terms of examination criteria, design has been defined as screen design that can be displayed on part of an article. Examination criteria has been established. Again, screen design that can be displayed on part of an article has been brought into the protection scope. So graphic user interface, icon, graphic image, and dynamic images are now being protected. So to look at the pictures below, these are included in the examination criteria, and these are not protected as a screen design because the part of the article that displays the design cannot be specified, or when it is realized through projection of light, it is considered as lacking article. So it has to be displayed on part of an article as a screen. And then we had other parts of an article or fonts or image design which did not have the element of article. So the Design Protection Act uses the concept of article as implied in law. So parts of article fonts and image design have all been included. And article is established as implied in law. So this provides protection for those parts of articles and fonts and image designs as well. And by image, the legal definition is a figure, symbol, etc., expressed by digital technology or electronic means. But there's a caveat to this, limited to those that are used for the operation of devices or that exhibit a function. and including parts of an image. So there is the functionality aspect. And in the metaverse, there are a lot of items that do not exhibit functions. So it's going to be difficult to protect all of the items in the metaverse. So we are looking at digital designs that do not establish part of an article on the screen, nor that those those that do not exhibit a function. So how we are going to protect those items was the focus of the project. So design within Metaverse, which lacks the article element. How we are going to protect those was the research question. And if you look at the pictures below on the slide, these are the representations or expressions of designs in Metaverse that lack the article element. So first is a digital product, in other words, items, and we have digital humans, digital animals, digital world, hologram. All of those are design representations within the metaverse that do not include the element or article element. And now we would like to look at some dispute cases on design in the metaverse. And what it was important here was metaverse design dispute cases. There weren't a substantial number of dispute cases. So our project was a little ahead of the times compared to other countries. And the fact was there weren't a lot of disputes that had actually taken place. And the earlier presentations focused on trademark. But I would like to say that in the design area, there are less disputes that have arisen up to now. Now, we did find some American cases. So there was the case on the Zap Blast Knuckle, which is a type of a stun gun. So the design for this was used by a video game producer, and if the appearance of the stun gun Zap Blast Knuckle was used in the game, would it be an infringement of design was the issue. The United States has a similar framework as Korea. So because the article was not the same, it was not understood as an infringement. External similarity alone cannot be deemed as design patent infringement. Again, here, the point was whether the design patent could be understood as being infringed when the article was different. And the second case was the Finnish nationally beloved character Moomin. So there were character shops online that were selling items that use a representation of that character. This didn't lead to an actual court case, but it was just mentioned in the press. And then Spoom case was when software was bought for a price without the agreement of the original artist or original author, and then implemented into another product and sold. So these were some dispute cases on design within the metaverse. Now, I would like to share with you some trademark cases and copyright infringement cases. So the first one I would like to share about the design was the Humvee design. So the outcome was that this did not constitute an infringement because artistic relevance, competitiveness, strength of mark, degree of similarity, and evidence of actual confusion. These were the aspects that were considered, and the real outcome was that the ruling was that this did not constitute an infringement. And then we have the Meta Birkin. Unlike the Humvee case, the reputation and the well-known status of the Birkin bag had been used, and it's more of a product than an article. And because it's more closely related to design, I wanted to share it with you. And then there was the Gulf Zone issue, the case where a golf course video had been infringed. This wasn't a copyright infringement case, but actually it ended up as a violation of the Unfair Competition Prevention and Trade Secret Protection Act. And the next case I would like to share with you is whether the dance moves of a character can be protected under copyright. It was mentioned earlier in another presentation because it was transformational use. And by transformational use, it refers to the American fair use. And because it comes under fair use, it was not infringement of copyright. And lastly, we had the tattoo on the basketball player's person. So whether this was an infringement. So this was another example of fair use in the United States. And also, there was the principle of de minimis. So this principle that is included in copyright was brought in to determine that this was not an infringement. Now, so those were some cases that I briefly touched upon. And then we conducted a survey to find out the opinions. So how much protection is needed and how protection should be extended. A survey was conducted on those issues. And digital design is being widely used. So in terms of the scope of use, the need for protection was widely agreed by those who were surveyed, and how digital design should be protected. Most of the responses, around 75% responded that digital and physical designs should be protected within the physical and digital world, and they should also be.
재미있다고 할까요?
And another interesting part was whether digital design and physical real-world design, how the protection relation is established. Digital design and offline design both should be protected was the answer from an overwhelming majority of the surveyed, like 90 to 100%. So offline design being used online, online design used offline, both should be established as infringement, was a demand from those that were surveyed. And according to current law, unfortunately enough, that is going to be difficult to be provided. And now we will have a look about the overseas protection status. Since a lot of information has been shared by presenters from other countries, I'd like to just briefly touch upon this. We have the case in the United States. In Section 171 on PHVAR design, there has been a report issued on whether application of Section 171 works. So opinions for application, opinions against application are detailed on the slide. So on the left side, we have opinions that are agreeing with the application of PHVAR design protection. And I read through this, and opinions for application or opinions for protection seem to have weaker grounds. So in other words, in the United States, A novel creative ornamental design on an article of manufacture seems to be more widely supported within the United States. Of course, it wasn't finally conclusive, and I won't go into the European Union case. Though I did prepare the slide on Community Design Regulation Article 3. And I would like to draw your attention to the product aspect. So Korea's Design Protection Act is focusing on article element, but EU Community Design Regulation focuses on product. So in the EU, the article element is not required in online or offline. So I believe that we could probably adopt this approach. This was a suggestion that was brought up in the very beginning of our research project. Now, in terms of article, building, and image, those are protected as designs, as was mentioned in the earlier presentation. And operation image, display image, design that includes image on part of an article are also included. But images in content are not protected. That's another point that I would like to share. And it is acknowledged within Japan as well that the range of protection provided by the current Design Act is insufficient to protect image design. And lastly, in terms of overseas protection status, is the case of Singapore. Registered Designs Act provides protection to features of shape, configuration, colors, pattern, or ornament applied to any article or non-physical product. But it doesn't have to have a physical form, but has to have an intrinsic utilitarian function. So a virtual instrument, a piano, is a non-physical product, but because it has a utilitarian function, it is protected. But a virtual character, because it doesn't have a utilitarian function, is not considered a non-physical product that can be protected. Now, digital design protection direction. So the article requirement issue and the definition of article is stipulated here. So it's not clearly defined in it's not clearly specified in the law, but we only look to case law. So independent, concrete, tangible, movable, the issues regarding each of the aspects have been described on the slide, and so the article requirement seems to no longer be very meaningful. So how we are going to deal with this should be gradually phased out is our suggestion. And in terms of the amendments that we should make regarding article requirement, according to our research team, we should eliminate the idea, ultimately, of article requirement and focus more on design concept. However, this article requirement is deeply enmeshed and embedded into the Design Protection Act, so we will have to gradually phase this out. We should gradually take this out of the law provisions. And we have provided 4 methods to phase out the article requirement, and method 4 is setting the design concept as an object of protection to ultimately delete the article requirement. In terms of, to go back to the top, method 1 is delete or revise the requirement that restricts image in regards with image design. And method 2 is introduce definition of article for digital design, including digital design and image design. And method 3 is to adopt the European approach and introduce definition of article in the European manner, while expanding the scope of the meaning of article, and method 4 would be setting design concept as an object of protection to ultimately eliminate the article requirement. So we thought hard about how to work with this. And we thought that the most feasible idea that could work for the time being would be method 1. But if you go with method 1, there might be some conflict with the copyright. And how are we going to resolve this convolution situation with copyright? In our report, we have described the pros and cons of the approach. So anyway, we have suggested some ideas to gradually phase out the element of article requirement. And again, some designs are protected in the digital world versus the physical world because they are assigned to different articles. And in the current law, if the article is different, then it is determined as dissimilar. And if the function and the purpose is different, and of course the function and the utility of the article would be different online and offline, then of course it can't be protected. So currently, under the current law, the only way to have the design protected is to register them separately in the online and offline world. However, in terms of creativeness, there might be ways to raise objections and prevent registering digital design.
디지털 디자인이라고 하는 것을
And lastly, coordination with Copyright Act to provide better protection of design is very important because Copyright Act protects a certain area which might coincide with the Design Protection Act's protection extended. Now, on the bullet points, there are stated the need for Design Protection Act for digital design, like strong industrial characteristic and practical purpose. Because Design Protection Act has industrial characteristics, they should be protected. Digital design should be protected under the Design Protection Act. But of course, the Copyright Act, proponents of the Copyright Act might come up with their own similar argument. And at the end of the day, we should not necessarily avoid conflict between the two parties. And the choice might be to have redundant protection. So the user, the party involved, might look at Design Protection Act or Copyright Act and choose whichever law to resort to, which provides better protection. So we believe that we could just allow for a redundant protection. And then also there's a conflict between different parties. And the intellectual property protection will provide protection. And grounds for invalidation, because the design protection right and the copyright, because there are different rights, it's going to be too much of a burden to try to invalidate this. So we decided to just leave it be. So this is what I have looked at in terms of design protection. And now I would like to turn to trademark. Now, when there's a digital product, the current Trademark Act, how it's going to apply, is becoming an issue. And there are a lot of reports on this. But what I have focused on in my presentation are 3 areas. First is use of trademark. What is the scope of the use of trademark that is recognized by the law? And because my colleagues had proposed some recommendations on how the Trademark Act should be amended, I have added those details. And second of all, there's trademark infringement. So if you look at the Trademark Act, infringement deemed as infringement is based on similarity, not identical infringement. So one suggestion by my colleagues is that identical infringement and infringement by similarity shall both be clearly stipulated as direct infringements. And to look at the subparagraphs 2, 3, and 4, they focus on counterfeiting situations. So there are stronger laws in the overseas about penalties for counterfeit. And the recommendation from my colleagues was that we should also make stricter the crackdown on infringement. And so there were ideas for amendments of the Trademark Act. And there are also comparison with other markets such as the United States, and I won't go into much of the details because my colleagues, my other presenters have said this. In the United States, having the trademark attached, physically attached, that requirement has been relaxed quite significantly. And the trademark use conditions aren't as significantly factored into in the United States. And we have infringement and counterfeiting infringement, and only counterfeiting infringement is criminally prosecuted. And in terms of Europe, I'll just skip over the presentation slides. There are demands for much stricter criminal punishment, but this has yet been legislated, and I will not go into details about the Japanese case as either. For acts deemed to constitute infringement, yes, I must touch upon this, because this article, for acts deemed to constitute infringement, a lower level punishment is applied compared to a direct infringement. And Korean law has referred very much to this part. And also the Chinese case is described here. One thing I would like to share with you is that prosecution standards of judicial authorities for infringement are very high, so very rare for an infringer to actually get criminally punished. So in terms of the use of trademark, the current Trademark Act fails to clearly capture online transmission of digital products or provision through streaming methods. So provision through telecommunication lines has been amended, and exhibiting, exporting, or importing for the purpose of provision through a telecommunications line is currently described here. And what we would like to look at are items C and D. So use of trademark referred to displaying a trademark on advertisements for goods, price tags, transaction documents, or other means. Displaying a trademark on information that includes details on advertisements for goods, price tags, transaction documents, or other means, and providing it through a telecommunications line should be added. So provided through a telecommunications line has already been added, actually. And then in terms of trademark, item D, comprehensive use. So using the trademark to indicate the commercial source of the product should also constitute use of trademark. And in terms of jurisprudence, we could have a rather more relaxed and a wide, broadened scope of interpretation to make these provisions more comprehensive in their scope. So in terms of jurisprudence, it is in items C and D, there should be more of a scope captured than included. And in terms of trademark infringement based on similarity should be also included in direct infringement. So it's only used as on a confirmational basis, but now it should be used for it should also be understood as part of direct infringement. So it should be added to the direct infringement conditions. Now, in terms of acts deemed infringement, there are items 1, 2, 3, 4, and there should be very strict prosecution and criminal prosecution and penalization be included into the amendments for items B, C, and D. And so the first suggestion is about amending item B, and the suggestions for amending item C and D are similar. So importing and manufacturing should be included, and delivery and a sell should be replaced with the words transfer and deliver. And so there are similar suggestions for items B and C. All of these details should be included so that the digital aspect should be included and captured in the definition of infringement. So this applies similarly to item C and D. And my colleagues also suggested that acts deemed infringement should include the following two. One is when a trademark has been modified and products that have the modified trademark attached are sold. And when the utility or the functionality of a product has been damaged, then that should also be considered as an infringement. And personally, counterfeited products, if they are also considered as infringement, this could provide better protection. Those were two suggestions that my colleagues made. And about criminal prosecution of infringement, in acts deemed infringement, items B, C, and D, we had referred to the Japanese law. Direct infringement should include infringement based on similarity, and imprisonment up to 7 years and 100 million won fine could be applied. But for a similarity infringement or acts deemed infringement, there should be stricter penalties levied. And in terms of confiscation, there should be a provision about confiscation. So this was a summary of what I reviewed in my colleagues' project on improving the protection for trademark for the metaverse and the digital world. And so those were some suggestions on how the laws should be amended for better protection with the metaverse. Thank you.
네, 김창원 한바대학교 교수.
Thank you very much, Professor Kim, for your presentation. Actually, I had majored in design and I had actually worked as a designer before becoming a newscaster. So as also a person who was involved in design, it was a very interesting presentation. So that brings us to the end of session number 2. We're going to have a break. It's 3:44. So we're going to have a 30-minute break, and then we'll go on to session number 3. So it's now actually 3:45. So see you back at 4:15, 30-minute coffee break. Thank you very much.